Good morning, everyone, and welcome to our webinar looking at the Data Sharing and Governance Act 2019. My name is Catherine Allen, and I'm the head of the Public Regulatory and Investigations team here in MHC. I'm joined this morning by Lisa Joyce and Aoiffe Moran. Lisa is a partner in our PRI team also. As you might expect, she advises public and regulatory bodies and people dealing with such bodies on what they can properly do, fair procedures, statutory interpretation, and all types of public law litigation. In addition, Lisa has a particular focus on information law, and she advises extensively in relation to all aspects of access to and disclosure of information, so things like freedom of information, AIE, and of course, data protection and data sharing, which is our focus this morning. I'd also like to introduce Aoiffe. Aoiffe is a senior associate on our PRI team, and she has over 10 years of experience in public and regulatory law. She also provides specialist advice to public and regulatory bodies on all of their functions, to include statutory interpretation, governance issues, policies, procedures, and she's represented various statutory bodies in judicial review and other public law litigation in the High Court and the Supreme Court. And she's also advised statutory bodies on the investigation and prosecution of complaints. So you'll notice a Q&A function on your screen. So we have some time at the end of this morning's session for Q&A. So please do enter your questions as we go along, and we'll try to answer as many as possible at the end of the seminar. And in addition, just to keep you on your toes, we have some poll questions coming up during the webinar. So we look forward to getting your responses to those during the webinar. Before I hand over to Lisa, I'd like to discuss for a moment a key definition in the Data Sharing and Governance Act, which is the definition of public body. And Lisa and Aoiffe are going to discuss why that definition is so important, but I would just like to introduce it by talking about what is covered by the definition for a few moments. So the term is defined in section 10 of the Act, and it includes all of the usual suspects, so government ministers, the HSE, local authorities, bodies set up by or under statute in respect of which a public service pension scheme exists or applies or may be made. Now, there are exceptions for companies, for some types of companies set up under the Companies Act, of course. It also includes education and training boards, recognised schools established and maintained by ETBs, and boards of recognised schools established and maintained by ETBs. But also importantly, the definition includes a body that is wholly or partly funded, directly or indirectly, out of monies provided by the Oireachtas or from the Central Fund, and in respect of which a public service pension scheme exists or may be made. So it does extend the definition quite broadly. And in addition, the Minister for Public Expenditure and Reform can, at the request of a public body, at the request of a body that doesn't fall within the definition of public body, the Minister can, at the request of that body, by order, provide that the Act applies to that body, where that body is funded either directly or indirectly by monies provided by a minister or loans guaranteed by a minister, and where the Minister for Public Expenditure and Reform is satisfied that the principal activity of the body is the delivery of services to the public under an agreement with a public body. So no such orders have yet been made. As you might imagine, there are also some exempted bodies. So these include bodies set out in the schedule to the Act, such as the Central Bank of Ireland, DAA, Airgrid, Arvia, RTE, Horse Racing Ireland, and subsidiaries of those bodies. It's also open to the Minister by order to exempt a body which would otherwise fall within the definition of public body. And again, no such orders have yet been made. And in addition, certain types of schools are also exempt. Therefore, as a starting point, it is important for all bodies that have some connection with public service to consider whether they might fall within the definition of public body or indeed be exempt from the definition of public body, and then take whatever steps are necessary pursuant to that analysis. So that's all from me for now. I'd like to hand over to Lisa and Aoiffe. Thank you.
Thanks, Catherine. So I'm going to start with a quick rundown of what we're going to cover this morning. So we might just move on to the next slide, please. Thank you. So we're going to look at the purpose of the DSGA. That's the acronym we're going to use for the Act this morning. That's obviously the Data Sharing and Governance Act. So we're going to look at its statutory purpose. We're also going to look at some of the key provisions of the Act and the key requirements. We're then going to look at the governance framework. So who plays a role under the Act? What personnel within public sector bodies will have things to do, and there are lots of things to do under the Act. And we'll also take a very quick look at some of the guidance that has issued so far relating to the Act. And then lastly, we're going to look at the key steps that need to be taken by any public sector bodies covered by the Act between now and the 31st of March 2022. So not very long to go. So I suppose the first point that I wanted to make is that we're looking at this Act now, and we're, in my mind at least, referring to it as a new Act, but it has been on the books, on the statute books, since 2019. And the reason I suppose it's coming up for consideration now is that most of its provisions didn't take effect until last summer, until July 2021. And the final two provisions of the Act are only due to take effect on the 31st of March 2022. And there's some significant implications by the final two provisions taking effect. So I suppose that's why we're looking at this kind of old Act in a new way now. So as Catherine mentioned, we do have some poll questions, a few poll questions for you all to keep you engaged with us this morning, hopefully, and also just to get a sense from the audience of their understanding of some of the provisions of the Act. So we might start with the first poll question, please, if we could bring that up. So the question is, are you familiar with the legal requirements under the Data Sharing and Governance Act? As I said, it's been around since 2019, but is only really kicking into gear relatively recently. So the answer is not at all familiar, a little familiar, or very familiar, and you can choose one of those. And just to explain, you can't get rid of that screen unless you vote. So hopefully it's not too taxing for you to vote and get rid of that screen. And we'll come back to the answers. We'll come back to the answers a little bit later on in this morning's session. So I actually need to vote as well, and it's not working for me. Okay, so we'll come back to the questions on that later on. So turning then to you, Aoiffe, and the first topic for this morning. Can you tell us a little bit about what the DSG Act is all about and the purpose behind it?
Certainly, Lisa, and we might move on to the next slide, please. So the Data Sharing and Governance Act, or the DSGA as we will call it, provides a statutory basis to allow public bodies to share personal data when providing public services. And it's part of a package of measures which the government is introducing as part of the Public Service Data Strategy 2019 to 2023. And I suppose the purpose behind that strategy is to assist in a more joined up whole of government approach to how data is used, reused, secured, governed and managed within the public service. And that's for the benefit of both individuals and companies. And the DSGA is not only a data sharing act, it's also a governance act. And I suppose the key is in the name. And it envisages an added layer of protection around data sharing within the public sector. And it does that by way of doing a number of things. Firstly, it requires data sharing agreements to be put in place in certain circumstances, including public consultation in setting these up. It also establishes or has established the Data Governance Board, which is charged, among other things, with promoting compliance by public bodies with the Act. The Act also sees the Minister establish data access portals, and what they will essentially streamline the process whereby individuals may access their GDPR rights. And they include the right to see and access what public bodies hold about them, the purpose for which that information is held, and what processing is being carried out in respect to that information. Other rights include the right to rectify any erroneous information, erase, or indeed object to processing. And lastly, the Act also enables the Minister to establish a base registry as a single source of particular personal data. So, and those base registries will have added security measures, and the data held in those base registries can then be reused by other public sector bodies. But I would say one key note or key point to note in respect of the Act is that its requirements are in addition to, as opposed to instead of, data protection legislation. So therefore, I would strongly encourage that you should continue to have regard to all DP legislation and indeed any guidance issued by the DPC when processing or sharing personal data.
Thanks, Aoiffe. So I think it's clear already that, as I said earlier, that this Act does cover a lot, and we will look at some of the key provisions shortly. But just firstly, I mentioned earlier that there has been a phased approach to the implementation or commencement of this Act. And I'm sure the logic behind that is that to allow everybody to prepare for its full implementation, including the new data sharing and governance board that you just mentioned. Can you tell us a little bit more about those stages, what those stages have been, and what public bodies can expect to happen on the 31st of March?
Certainly. And we might move on to the next slide, please. So, as you said, Lisa, there has been a phased approach. And the first date in the diary, or key date, was the 9th of April 2019, a long time ago at this stage. But at that point, we saw the preliminary and general provisions commenced. We also saw the commencement of Part 5, which relates to collecting and processing of specified information regarding the Public Service Pension Scheme. And we also saw certain provisions enabling the Minister to make directions, etc. Then moving on to the 7th of July of last year, and that date saw a significant set of commencements. So essentially the rest of the Act, other than Section 6.2 and 6.3, were commenced. And I'm not going to go through all of those commencements, but crucially, we saw the establishment of the Data Governance Board in July of last year. So that allowed it to commence its work, and certainly it has been doing so. It has had meetings since then, and the minutes of those meetings are available online if anyone wants to take a look. We also saw the commencement of Section 13 of the Act, and that is a very key provision. I'd recommend any public bodies to have regard to it. What Section 13 does is it specifies the requirements that must be met before disclosure of personal data by one public body to another public body under the Act. So then moving on to the 31st of October, that is not a statutory date, but it is a date by which the Data Governance Unit within the OGCIO, that's the Office of the Government Chief Information Officer, required a number of steps to be taken by public bodies. Firstly, it asked public bodies to compile a list of data sharing arrangements that rely on Section 38 of the Data Protection Act, and it provided a template to public bodies to complete. And just a reminder of what Section 38 of the DP, or Data Protection Act, is. It essentially permits the processing of data for the performance of a function or task carried out in the public interest or in the exercise of official authority. And so public bodies were asked to complete or compile a list of data sharing arrangements that relied on that section. And secondly, they were asked to complete a mandatory return detailing the data sharing arrangements that relied on Section 38. And even in circumstances where public bodies did not rely on Section 38 at all, they were still required or requested to return that mandatory return, specifying that they didn't rely on Section 38. So that was the 31st of October. Then moving on to the 6th of January was a date by which the OGCIO requested that public bodies have all model or draft data sharing agreements and data protection officer statements ready for public consultation. Just to note, data protection officer statements are essentially a statement by the data protection officer within the public body concerned, confirming that, in their view, the data sharing agreement or the proposed data sharing agreement complies with the provisions of data protection legislation. And then moving on to the 31st of March of next month, I think it's just over 7 weeks away, we will see the final commencement of Section 6.2 and 6.3 of the Act. And what they will do is they will nullify Section 38 of the Data Protection Act as a legal basis for data sharing between public bodies. So this means that any existing data sharing arrangements that use Section 38 of the Data Protection Act as their legal or lawful basis for sharing will no longer comply with GDPR. So those arrangements should therefore be reviewed and updated so that they comply with the provisions of the Data Sharing and Governance Act.
Okay, so we've looked now at the purpose behind, the kind of high-level purpose behind the Act, and also the kind of history or the phased implementation that's taken place to date. So I think we need to look at what the Act actually means in practice for public sector bodies that are covered by it. We're obviously talking about data sharing. It's in the title of the Act. Can you tell us what the Act considers data sharing to be and what type of data it's actually talking about?
Certainly, and we might move on to the next slide, please. So what is data sharing? A good question. So the DSGA defines data sharing as the disclosure of information to include personal data by one public body to another public body. And happily, personal data has the same meaning as it does under GDPR. However, the Act does apply in certain instances to the data of deceased persons. So obviously personal data under GDPR doesn't apply to deceased persons, but in this case it will, so that whenever you see a reference in the Act to person, this includes a deceased person. And I suppose the logic behind that is to allow for records held by public bodies relating to deceased persons to be updated or shared following a person's death. So I have there in the second bullet point, special categories of personal data. The general rule is that the Act does not apply to the sharing of special categories of personal data. Now, there are two exceptions to this. And what I mean by this is there are two instances where the Act will apply to special categories of personal data. And the first is where the sharing of personal data relates to the administering of the public service pension scheme. So as I mentioned earlier, that's referred to in part 5. So where sharing relates to the public service pension scheme, the DSGA allows the sharing of special categories of personal data. The second exception to the rule that the Act does not apply to special categories of personal data is where the data is processed so that it may be accessed through the personal data access portals that I mentioned earlier on.
Okay, and when we talk about special categories of personal data, they used to be called sensitive personal data pre-GDPR. So we're talking about personal data that relates to your health or ethnicity or sexual orientation and that type of thing, just in case there's obviously parallels between GDPR and this Act, and they continue throughout the rest of the session. So just, I suppose, to clarify that for people, just in case. So I'm going to ask you next about what the Act says, or when the Act says that public sector bodies can actually share personal data, which generally excludes special categories of personal data, as you've just said. But maybe before we get on to that, it's a good time for a second poll question. So if we can have the second poll question up, please, that would be great. Thank you so much. So the second, a lot of public sector bodies do already share data with other public sector bodies, whether it's their governing department and so on. So I suppose before we get into the specific requirements of this Act and how it might change, let's just look at what happens currently. So what does your organization rely on to share data currently with another public body? Is it Section 38 of the Data Protection Act 2018? And again, Aoiffe reminded us earlier, but just another reminder, Section 38 permits processing of data for a task carried out in the public interest. So, for example, the administration of a non-statutory scheme. So it's quite a broad legal basis for the processing of personal data under data protection. So do you rely on that one if you share any data with another public body? Do you rely on another specific legislative provision? So there's another provision in an Act that applies to you, which tells you you can share this data or that you must share this data. Or do you not know? does it happen? And you just don't know what the legislative basis is for it. So again, the box will disappear once you vote. It's not working for me still, but that's okay. It'll all be a surprise when we look at the results of the poll later, which we will do. So while we wait for those answers, we'll just move on to the question that I'd already mentioned, Aoiffe. What does the Act say? When does the Act say, rather, that public sector bodies can share personal data?
Certainly. And we might move on to the next slide, please. So Part 3 deals with the regulation of data sharing under the DSGA. Happily, it has 2 sections. I'll deal with section 14 first. It's more straightforward, I think. So section 14 entitles the minister, with the consent of other relevant ministers, to direct a public body to disclose personal data from one public body to another. So that's relatively straightforward. There is a safety valve contained in section 14 of the Act, which allows the DPC to essentially impose a temporary limitation on the disclosure or the direction in relation to disclosure. So the reason I'm drawing that to your attention is, again, just to serve, because it serves to demonstrate that, I suppose, notwithstanding the provisions of the DSGA and the oversight role the Data Governance Board has, all processing of personal data carried out under the Act is subject to ultimate supervision by the Data Protection Commission. Okay,
so that's a pretty simple one, as you say. The minister can direct public sector bodies to share in certain circumstances. What if the minister hasn't issued that type of a direction? What are the requirements for data sharing then, or when can you do it?
Yeah, so we'll firstly deal with a specific provision. So the requirements, if you have a specific provision in the legislation which you're operating under. And remember that as of the 31st of March of this year, section 38 of the DP Act can no longer be relied on. So section 13.1 says that section 13 applies where, and it's there in the third bullet point, there is no law of the EU in operation under which specific provision is made, permitting or requiring such data sharing. So that means that essentially, if there's a specific provision, or the remainder of section 13 will apply, although the term specific provision is not actually defined in the Act. So I guess the correct meaning is open to interpretation until determined by the courts or by the DPC. But helpfully, the OGCIO has given some examples of what specific provisions may look like. And we have put up one of those examples on the next slide. So we might move on to the next slide, please. So you'll see there, and I acknowledge it's quite small, but that serves to demonstrate how detailed the provision actually is. So you'll see there that it's section 265 of the Social Welfare Consolidation Act of 2005, and it allows sharing by specified bodies as defined in that Act, only for relevant purposes, and relevant purpose has quite a specific definition as well. And the sharing is also subject to very specific requirements being fulfilled by the body seeking the information. Those requirements include, for example, satisfying the controller of the information is relevant to the transaction. So as you can see, the provision required is quite specific. And as I said, if the operating legislation or the legislation under which you're operating contains a specific provision, then you do not need to address the additional requirements of section 13.
Okay, so we've seen now 2 ways that public sector bodies can share data between themselves under this Act. The first is if the minister directs them to do it. The second is if you have this type of a specific legislative provision that is permitting or requiring the data sharing to take place. And again, I can barely read that slide, the level of specificity required in that, the type of legislative provision that will get you over that hurdle seems to be extremely high. And I think it will probably require analysis of each relevant legislative provision by the public sector body or your in-house lawyers or your external lawyers and so on, just to make sure, will it actually meet that requirement? So what if the minister hasn't directed you to share the data, you don't have this type of a specific legislative provision, or there is, an unspecific legislative provision that you maybe have relied upon in the past? What does that mean? Are you not allowed to share data, or do you just have to jump through some more hoops?
I think it's the latter. There are hoops to be jumped through. So we might move on to the next slide, please, and we just go through some of those hoops. So if there is no specific provision, the requirements under section 13 are as follows. So the first requirement, we might just pull that up there, is that the public body must demonstrate that the personal data concerned is disclosed for the purpose of the performance of a function of either public body, either the first or the second public body. The next requirement is that at least one purpose set out in section 13(2)(a) is satisfied. And as I said, section 13 is a really key requirement of the Act. So we've put up one example of a purpose there. It's to support the once only principle, but there are 7 more. Just to expand on what the once only principle means, it is that essentially the persons shouldn't have to provide the same information multiple times to multiple different bodies. So it's really to avoid the financial and administrative burden on the individual as opposed to the public body, and that's important to remember. Other purposes contained in that section are such, examples to verify the identity of a person, to correct erroneous information, to establish the entitlement of a person to a service. I won't go through all of them, but there are some of the examples. So then moving on to the next requirement, and this is probably the requirement that's gotten the most headlines, is the requirement to put in place a data sharing agreement. And that data sharing agreement must comply with Part 4 of the Act. And it's important to remember that the data sharing agreement must be entered into prior to the disclosure of the information. And section 19 of the Act details the requirements of the data sharing agreement, so what needs to go into the agreement. And they're detailed, they're specific. I'm not going to go through all of them, but they include information such as the function of the body, the type of data being shared, the impetus for sharing, etc. I suppose public bodies are also required under the Act to use the model data sharing agreement if one has been provided by the Minister, and that's set out in section 66 of the Act. And I would mention that there is a draft data sharing agreement on the OGCIO's website, which is being piloted. So it may be revised, and I understand that it's on draft 4 at the moment. So if you are using the template that's available on the website, just make sure that you are using the most up-to-date version. So moving on then to the next requirement, it is that the personal data has been lawfully obtained and held by the first mentioned public body. Now, in some ways that should go without saying, but that is something that you must have regard to. And then the next requirement, and we see again echoes of and re-emphasizing of requirements under GDPR here, that the disclosure of the data must be necessary and proportionate. And then the next is, and the next, the final one is that there is a requirement to comply with any rules, procedures, standards, and guidelines issued under section 64 and 65 of the DSGA. And helpfully, the policy unit within the data, the OGCIO, has issued very helpful guidance to date, and we'll get on to briefly mention some of that guidance in a future slide.
Okay, so again, just to recap, before public sector bodies can share personal data with another public sector body, they need to either have a ministerial direction requiring them to do it, or a very specific legislative provision that permits or requires the data sharing, or else they need to meet all of these other requirements under section 13, the main one being that you need to have a data sharing agreement in place under the Act before the data sharing takes place. So when it comes to a specific legislative provision, you pointed out earlier that section 38 of Data Protection Act will no longer apply or can no longer be relied upon as a legal basis justifying the sharing of data between public sector bodies, and that's going to kick in from the 31st of March. So that means if public bodies are currently relying on section 38 to share personal data with another public sector body, then they're going to have to meet all of these requirements of the Act after 1st of April, essentially. What does that mean for Section 38 then going forward? Is it just gone, or can it be relied on by public sector bodies in any circumstances?
Yes, and I think this is a good point to emphasize, and we might move on to the next slide. Just to be clear, Section 38 isn't a distant, or won't be a distant memory after the 31st of March. It certainly still is in the statute books, and it will remain a valid legal basis for all forms of processing which fall within its scope other than data sharing between public bodies. And that is set out very clearly in the OGCIO guidance. The quote is on the slide. So what that means is, while you can't rely on it for sharing from one public body to another, public bodies can still absolutely rely on it for internal processing within the public body, or indeed sharing of personal data between themselves and, for example, a private entity.
Yeah, and that would obviously be subject to otherwise fully complying with the GDPR.
Absolutely.
Okay, so that's good to know. It's not gone completely, because I know we did have some clients that were kind of worrying that might be the case. And as I mentioned earlier, it is a very wide legal basis, and one that is relied on extensively for processing in the public interest, essentially. So you also mentioned earlier that there are certain types of what would be normally considered public bodies that the Act doesn't apply to, and Catherine also gave examples of some of those from the schedule to the Act. Are there certain types of personal data that the Act doesn't apply to also? You're just on mute there, Aoiffe.
Thank you. Yes, indeed there is. And we might move on to the next slide, please. So Section 12 deals with the exclusions. So essentially what that means is that these are instances where, while the public body may be subject to the Act, a certain personal data that's being shared, the Act will not apply to. And those exclusions include law enforcement, public safety, protecting the security of the state, preventing, detecting, investigating offences, that sort of thing. I draw your attention to the final bullet point. And what that provides is that the Act does not apply to the disclosure by one public body to another of personal data for internal administrative purposes. And the Act specifies that this includes purposes relating to the employment of the data subject concerned. So this might include passing of information between public bodies relating to employees, potentially. And in that case, the Act does not apply. But one thing I would remind you of is that the Public Service Pension Scheme is dealt with or treated differently under the Act. And so transferring information between public bodies for the administration of, or indeed passing and transferring to the ministers or relevant ministers for the purpose of the Public Service Pension Scheme is covered by the Act.
Okay, so we've looked at when public sector bodies can share and what they need to do in order to lawfully share data with another public sector body, and the exclusions, as you just talked about there. Another term that you mentioned at the outset was base registries. What are these? What does the Act say about them?
Yes, and we might move on to the next slide, please. Thank you. So the Minister is empowered under the Act to designate a database owned by a public body as a base registry. So as you ask, Lisa, what is a base registry? It's essentially a database of personal data. The idea of base registries is it derives from kind of the European Commission, and it's an initiative that's being driven by the European Commission. And the concept around it is an idea of an interoperable Europe, so that that the Commission is pushing the transformation of public administrations across the EU and driving their digital transformation, and also I suppose making it easier for personal data to be transferred within public bodies, within countries, but also cross borders as well. So the Commission describes base registries as reliable sources of basic information on items such as persons, companies, vehicles, licenses that are authentic and authoritative and form the cornerstone of public service. So what base registries are intended to do is to improve the quality of data across the public service by, I suppose, reducing the number of independent copies of the same data, and instead focus resources on the security and protection of one single data source containing that data, as opposed to having multiple copies held by lots of different public bodies, which may not be up to date. And development in this area is ongoing, and so there may be a lead in time before any base registries are fully up and running. Now, it's on the second bullet point there, you'll see that the base registries, they do not apply to special category data. So what I mean by that is that special category data won't be held on base registries. And there are, unhappily maybe for base registry holders or those deemed to be base registry holders, there's additional obligations on base registry holders, and they relate to maintenance, making sure that the information contained on the base registry is kept up to date, and publishing terms and conditions around access to that data. And I suppose that's to improve the security around the data that's held. And the other thing to note is there is an obligation, a specific obligation in the Act on public bodies to use base registries and use the information that's contained in those base registries, as opposed to getting that information from another source. So that means that they wouldn't be able to ask the individual for the information again, they would have to use it from the base registry.
And that ties in with the once only principle that you mentioned earlier as well, which is kind of one of the main purposes of the Act. So I mentioned at the start that one of the things we were going to look at was kind of the governance framework and who were the people within public sector bodies that were going to have to do all of this and implement all of it. So what does the Act or the guidance that's been issued say about who will fulfill all of the various roles required within the public sector bodies? What roles are envisaged, I guess?
Sure. So there are a number of roles. We might just move on to the next slide. We've set them out there. And they can kind of be divided into two camps, essentially. We'll deal with the first camp first, which is the role of the OGCIO. And their role is to implement the public service data strategy, which I mentioned at the very outset of this strategy from 2019 to 2023. And both the data policy team and the data governance unit sit within the OGCIO, and they are working hard to issue policies and procedures under the Act. And the data governance unit also, who are working hard to coordinate the consultation process and all of the administrative requirements under the Act. And then also, and I suppose the data governance board sits, but they are independent. Their role is to promote compliance with the Act, as I said, but they will also be required to review data sharing agreements prepared pursuant to the Act. And they have set up a committee called the Data Sharing Committee to review those agreements and to report into the board. So I have no doubt that that committee is going to be quite busy over the next few weeks and months. So then moving on to the type of roles that you would see in the public body. So firstly, I've mentioned there the lead agency. So what the lead agency is the public body that is essentially responsible for ensuring the completion and publication of the executed data sharing agreement. So obviously there's two public bodies always involved in data sharing, and one of them is going to have to take the lead. It'll tend to be the controller of the data or the holder of the data. And so there have to, and if both public bodies are controllers, there will then have to be a decision as to who's going to be the lead, or which body is going to be the lead agency. Then we have the data officer, and that's a term that's not defined in the Act, but it is set out in the guidance, and the guidance recommends the public body should nominate a data officer who will essentially act as a data advocate within the organisation for data sharing. They'll also coordinate and prepare any new data sharing agreements. They'll be the point of contact for the other public body, and also for the data governance board and the data governance unit on all matters relating to the sharing of data. And then we have the DPO, or the data protection officer, and that's a term that we're already familiar with. It's a term that's set out in GDPR, and the role of the DPO under the Act will be to review any proposed data sharing or model data sharing agreements, and to essentially confirm that they're happy that the data sharing agreements comply with the provisions of data protection legislation and that they're consistent with data protection law. And then finally, we have the authorized signatory, and that is a person who is it's a senior official or principal officer or equivalent within the public body who will essentially sign off on the data sharing agreement that is ultimately published, and they'll execute it, and they'll be accountable then for the data sharing within the public body concerned. And I suppose to note that an authorised signatory is required to sign the DSA after all recommendations made by the Data Governance Board have been addressed, and before they'll sign it then once all of the concerns, etc., have been addressed, and then it'll be posted on the lead public body's website.
Okay, so now we know who's going to undertake compliance with the Act generally within public sector bodies. What are the next steps then? If public bodies do need to put in place a data sharing agreement because they were relying or are relying on Section 38 of the Data Protection Act to carry out that data sharing, and now won't be able to from the 31st of March, they now need to put in a data sharing agreement in place because they don't have another specific legislative provision. What are the steps then that they need to look at?
Yes, sure. So we might move on to the next slide, please. There are 9 steps, and they are set out in a lot of detail in the data sharing guidelines and the playbook. That both of those are available on the OGCIO's website. I'm not going to run through all of the stages. Some of them are self-explanatory. For example, stages 1, 2, 3 involve preparations for public consultation. So identifying the personal data that you require, that may be done by contacting the public body who holds it. If you're not sure who might hold it, you can check the data catalogue, and I have the website there for your reference. Determining the lead agency, carrying out a data protection impact assessment if one is required, if there's a concern that there's impact on the rights and freedoms, or high risk to the impact of rights and freedoms of individuals. Preparing the draft data sharing agreement using the template, notifying the Data Governance Board, and placing necessary notifications on your website. There's some of the requirements set out in stages 1 to 3. But then stage 4 is the public consultation, and that the Data Governance Board has specified that will be a 28-day period. And essentially, by that stage, you will have your draft data sharing agreement. You'll have your DPO statement confirming compliance with data protection legislation, and your DPIA summary, if a DPIA is required, or if not, summary as to why it's not required. And all of that information will be publicly available on the consultations page of gov.ie for a period of 28 days. Then moving on to stage 5. So following the public consultation, the public bodies will have a 21-day period that's been set by the Data Governance Board to review the submissions received following the public consultation, and update and resubmit any documents or further information to the Data Governance Board that the public body thinks may be relevant for the Data Governance Board to consider. So that might include reasons why they haven't taken certain submissions into account in reviewing the draft agreement. And then stages 6 to 7 involve the Data Governance Board's review and any further exchanges between the board and the parties until the ultimate draft is agreed by all the parties and then executed by the authorised signatory. And so then at stage 8, you'll have publication, and there's a requirement there in the Act that takes place 10 days after the execution, and that the data sharing agreement and ancillary documents are required to be published by the lead agency and also the Data Governance Board as well. And then obviously stage 9 is implementation. You have your data sharing agreement in place and you are ready to share data.
So I'm no mathematician, but if there's 7 weeks between now and the 31st of March and you have a 28-day consultation, a 21-day review period and 10 days to publish it after it's signed, I'm just not sure how realistic, unless people are well down this track already, that's possible before the 31st of March. So this really, I suppose, does need attention immediately from affected bodies. I know that you had a list of the guidance to date on the next slide. You might just take a look at that really quickly, because I'm just conscious of time and I want to look at the poll question answers as well. Can you move on to the next slide? Yeah. Perfect. So that is just a list of everything that has been published to date, and it's all available on the OGCIO website, and you've given the link for that already, and we'll obviously be circulating the slides. So you'll have, afterwards, you'll have this list and you'll have the link to the OGCIO website. I might just skip on then and look at the poll question answer, the answers to the first two poll questions, if that's all right. Yeah, so again, the Act has been on the books since 2019 and is really soon going to be implemented in full. And we can see that 58% of the audience are a little familiar with the Act. Very few are very familiar. That might be me and Aoiffe answering that question, although I couldn't vote actually, so it's definitely not me. And 36% not at all familiar. So really this is something that needs attention from public sector bodies very quickly. Can we look at poll question 2? The answer there. Perfect, thank you. So what does your organization currently rely on? So you can see 29% rely on Section 38, 34% have another, they think they have another specific legislative provision. Will that meet the threshold under the DSG Act? Will it be specific enough? And then 37% don't know what basis, legislative basis they're relying on to share data. So again, if you are relying on Section 38 or you don't know, the chances are you might need a data sharing agreement. And again, this is something that needs to be looked at urgently by affected public sector bodies. I just have one final poll question. I am conscious of time. We do want to leave as much time as possible for Q&A, but I just wanted to pull up one final poll question, if that's okay. Can we pull that up now? Sinead, I'm just wondering, can we perfect, thank you. So how ready is your organization for the full implementation of the Data Sharing and Governance Act? So obviously there's a lot to do, very quickly. And there's, those 9 stages that you need to go through to get a data sharing agreement if you need it before you can share data lawfully. So can we pull up that question again? I'm not sure if people got a chance to vote. Mine disappeared anyway, hopefully you did. The answers were ready or not ready. Perfect, thank you so much. And we just might look at the answers to that immediately and see how it's going. We put up the perfect. So yeah, 63% are not ready. That's to be honest, that's no surprise. And like I've said, I'm not sure it's actually feasible at this stage to get everything done before the 31st of March. So watch this space, I would say. I just had one final question for you, Aoiffe. What are the key steps that public sector bodies need to take between now and the 31st of March to try and get as much done as possible before then?
Yes. So yeah, we're at a point where we're 7 weeks away from public bodies not being able to rely on Section 38 to share of the DP Act to share personal data, and data sharing agreements will need to be put in place from the 31st of March onwards. So ideally, public consultations would have already started. However, key steps I would certainly recommend, and sorry, we might just move on to the next slide, please. So key steps I would recommend, if you haven't already done so, is firstly to complete a mandatory return. And I did see a question there as to what a mandatory return actually is. So what it is a template document, it's a spreadsheet, which has been supplied by the OGCIO to, I understand, Secretary Generals and data protection officers, although it may not have gone out to all public bodies. So if you haven't received it, I would recommend that you get in touch with the Data Governance Unit. Their details, contact details, email addresses and phone numbers are available on the OGCIO's website, and I would complete that mandatory return. So at least the OGCIO know that there is a situation where you rely on Section 38. Other things I would do is get your model data sharing agreements, get them up and running in terms of getting drafted, and obviously DPO statements will need to be ready to go as well for public consultation. If you haven't already done so, I would designate a data officer within your organization to be the point of contact between the organization and the data governance board. And then finally, I would suggest agreeing a list of authorized signatories so that there is a principal officer or equivalent available to sign the data sharing agreement. They know what their obligations are in advance.
Yeah, I think the really critical step there is the first one, because completing that mandatory, essentially what it is assessing whether you need a data sharing agreement or not. Are you relying on Section 38? Is that going to go from the 31st of March? Or do you still have some other legislative basis, which means you won't need to put in place a data sharing agreement? And if it's only if you need the data sharing agreements, everything else kicks off from there. So there are a good few questions coming in, Catherine. I can see, again, that doesn't surprise me either. We'll try and get through as many as we can.
Thanks very much, and thanks Lisa and Aoiffe for that really interesting discussion. And yes, lots of questions coming in. I have tried to answer some of them as we've been going along. Clearly, some of the questions are not one-line answers or one-sentence answers, so we might not get to the more detailed ones this morning, because I think we have 8 or so, 6, 7 or 8 minutes for questions, but we'll do the best we can. There's one question that's come up 2 or 3 times, and I think you might have already covered it in some way, but let's just go over it again. Can the data protection officer and the data officer be the same person? So Aoiffe or Lisa, I'm not sure who would like to take that one.
I'm happy to take that. Yeah, I have considered it, and it is a question that is coming up repeatedly. There's no express prohibition in terms of them being the same person. As I said, the data officer is not a term defined in the DSGA. The DPO is a term that's defined in GDPR, and that person must act in accordance with GDPR. The guidance that's issued from the OGCIO certainly suggests that the roles would be carried out by 2 different persons. So I guess the data officer is the advocate and the point of contact with the data governance board, and the DPO has more of an oversight role. So I think keeping the roles separate should, I guess, serve to I suppose, support the continued independence of the role of DPOs required under GDPR and avoid any conflicts of interest. But as I said, it's not expressly prohibited in the legislation, and it may well be worth contacting the data governance unit. They may have further thoughts on it.
I just want to take one of the questions which is related but not the same, which is, can the authorised signatory and the DPO be the same person? And I think that very much depends on the internal governance of the body in question. Clearly, to be an authorised signatory of an agreement on behalf of public sector body, you need to have the right delegations in place in accordance with your governing statute. The position of a DPO is one which is closely governed or regulated by the data protection legislation and requires independence of the DPO. I would have thought it's unlikely that a DPO can both maintain that independence and be a person who's an authorised signatory in accordance with internal governance requirements. I'm not saying it's impossible, but it would have to be analysed carefully as to whether that could actually happen in any particular case. So just take that one as it's related. Now, bear with me while I go to some of the other questions. We have a question there as to whether has the Minister designated any public bodies as base registries yet? Lisa, you're shaking your head there.
No, yeah, simple answer, I know.
Okay, that's quick. Very good. An interesting one here. How does the 2019 Act affect data sharing between public bodies for law enforcement purposes under Part 5 of the DPA? Is a data sharing agreement required? Now, it sounds to me like if you're sharing for law enforcement purposes, you're very likely to be doing that under a specific provision. But Lisa or Aoiffe, any thoughts?
Yeah, and also it's one of the exclusions under Section 12 as well.
Correct. So, well, that's even easier.
Yeah, exactly. So, and again, I suppose it just kind of supports that the GDPR and the Data Protection Act and this Act are designed to work in tandem. You know, they're not meant to, one is not meant to compete with the other. Yeah.
Okay. This is a question that we actually discussed when we were preparing for this webinar. Do you have any information on what internal admin purposes covers?
No. Again, pretty simple. I mean, it is an internal administrative purpose. If it goes beyond an administrative purpose, So Aoiffe gave the example of sharing data relating to employees. I think if you're talking about payroll, sharing with another government department who runs the payroll for you, or something like that, that might be an administrative purpose, which goes to the running of the organization. But I think anything beyond that relating to employee competence or anything like that would probably fall outside it. But there isn't any guidance on that as of yet.
Great, thanks, Lisa. A very important question that I think a lot of people will be asking themselves, given, was it 67% said they weren't ready at the moment for the full implementation of the DSGA Act. What are the risks of not being ready by March, and how can these be mitigated?
So there aren't any enforcement. I suppose the risk is that you are unlawfully sharing data between public sector bodies from the 1st of April, because you do not have a lawful basis to do it. If you are relying on Section 38, it no longer applies. If you don't have another specific legislative provision that permits or requires you to do it, then it is unlawful data sharing. And while there might not be consequences or enforcement under the Data Sharing and Governance Act, we are talking about personal data. So GDPR would kick in then, presumably. Aoiffe, did you have any thoughts on that?
No, exactly as you've just said. It's always worth bearing in mind that the Data Protection Commission, I know they were tangentially involved in the carrying out of, or the execution or drafting of this legislation, but they certainly were keen to maintain an independent kind of distance from it. So they'll be, I'd say, watching, or the Commission will be watching closely to see how this unfolds, I would say.
Yeah, I was just grabbing my my trusty copy of the GDPR there, which sits beside my desk at all times, just for the purposes of one other question there, which is, can a public body use GDPR Article 6(1)(c) or (e) as a legislative basis for sharing with another public body? So, I mean, that's a very astute question, because we've been referring to Section 38 of the 2018 Act all morning. We haven't once referred to Section 6 of the GDPR, but Section 38 is the implementation of Article 6(1), of Article 6(1) C and E in domestic legislative form. So the knockout of Section 38 of the 2018 Act does potentially knock out Article 6(1)(e), certainly, of the GDPR in terms of reliance as a legislative basis. So just be very aware of that. Under the GDPR, under Article 6, Article 6(1)(c) and E need to be implemented in domestic or EU legislation under Article 6(3), I think it is. So I don't know, Catherine, if you had any further comments on that.
No, I agree with all of that, Lisa. Thank you. I think we just time for two more questions, which are essentially on the same topic. So I'll take them both, if that's all right. It's, does the Act supersede previous DSAs already in place and embedded in the system? Do these DSAs need to be updated before the 31st of March? And then similarly, what if there is a contract, SLA, MOU between the public bodies for the provision of services? Does it now require compliance with this Act, even though compliance with GDPR is covered in the contract? Stroke SLA,
I think it's very difficult. It's very difficult to answer both of those questions in the absence of further information, because it will depend. You may have a data sharing arrangement in place with another public sector body, but that just could be, a formal or an implementation of where a specific legislative provision does exist already. So we can't tell you whether you need to put a formal data sharing agreement in place under this Act, unless we actually look at the specific purpose for the sharing, what the information is, and so on. And obviously check that we are talking about two public sector bodies as defined under the Act. So unfortunately, I can't say yes or no on the basis of the information we have from that question, or from both of those questions. Does that make sense?
I think that's fair to say, Lisa. So I think we have to leave it there. Unfortunately, we managed to answer 17 questions and we have 15 left open, but that's all. Sorry about that. That's all we have time for today. We really appreciate your attendance today. Thank you to Lisa and Aoiffe, both of our speakers, for that very interesting presentation. Thank you all for your attendance. We do have a SurveyMonkey survey, which will pop up straight after the webinar concludes. We really appreciate your feedback, and thank you very much again for attending. Goodbye.